Hey, good afternoon and welcome to Agri Talk. Today we're going to talk about ideas,
Ideas, yes.
kind of, and who owns those ideas?
Who owns those ideas? Who
Sometimes
may
it's not very
steal those
tangible.
ideas? Yeah, a variety of ways, I guess you could think so. Whether it's written in paper, a computer program, pictures,
it could be
you name
everything,
it. Yeah,
images and sounds and whatever.
yeah, absolutely.
Symbols.
And then maybe even how a person may steal that, or things that we just found out about, whether it's phones or taking pictures and stuff.
Yeah,
to
because
steal it.
information finds its way everywhere.
It does.
As we've seen on TV and different things.
And ends up on a lot of people's personal property, and via a phone or the cloud or a personal computer or something like that.
And then the disposal of those devices could be
Yep.
sticky if you don't watch yourself.
So this applies to really clear across the board in any business related activity, I guess.
Now it could be related to like music and movies and all this type of stuff. But today we're going to talk more about intellectual property as it relates to business.
Yes.
Okay, so who is our expert panelist?
Well, our expert today is Isaac Molnar, a intellectual property counsel for the Ohio Attorney General. Isaac, welcome to the show.
Thank you.
And Isaac, could you tell us just a little bit about yourself, and maybe how long you've been in the position, maybe a little bit of background?
Sure. I spent 13 years in private practice doing intellectual property litigation. And then about 4.5 years ago, the Attorney General created this position, Intellectual Property Counsel. It's the first time Ohio has had this position, and it's actually, to the best of our knowledge, the only such position in the United States. So it was, I think, a really unique, kind of visionary job that the Attorney General created. And when we talk about intellectual property in my job, I work with copyrights, trademarks, and patents. And with trademarks, you're talking about branding, your logos, your Procter & Gamble, your Crest toothpaste. With copyright, you're talking about works of art, original ideas like photos and books and paintings. And with patents, you're talking about ideas, technology, coming up with the next great idea, the Apple iPad or iPhone or things like that. And I advise state clients on that issue. And I also work in trying to promote economic development throughout the state, to talk to small companies or companies around the state, to talk to them about IP issues and try to help them with their intellectual property questions, and try to help them lower costs in the area and hopefully advance economic development in the state of Ohio.
Great. With that, just for the rest of the people, when you say IP, some people like myself, it's more technology oriented, thinks of something different. IP is intellectual property, right? Is that how that everybody interprets it differently, I guess?
That's right. Intellectual property, or IP, in the law, certainly it's IP refers to intellectual property as opposed to when you're in IT and you're working with the internet, you have your internet provider and things of that nature.
Right. That's always a good idea. So with this, where would a person start if they're thinking about even starting a business? Do you work with startups, or do you say, no, I come in at this point? Where do you start your process, maybe?
Yeah. So I think our biggest value add is with startups or smaller companies. So I refer to them as pre-revenue companies, but startups is fine. And the reason why we can really be in assistance to those types of companies is that they don't have intellectual property counsel. They don't have attorneys that they're paying that know or understand IP issues. Whereas your larger companies keep or typically have in-house counsel that are experts in intellectual property. So what I'm able to do then is come in and talk to those companies about patent issues or copyright issues or trademark issues, and give them guidance that they'd otherwise have to pay for, and point them to sample documents or agreements that they might be using in their company that they're able to use without paying the cost of attorneys. And when you're talking about startups and you're talking about these smaller companies, money is really, really important to them. So, saving them $1,000 can be really impactful.
Really good, yeah. So go ahead.
If you're starting a company, the first thing, after the idea, hey, I'm going to do this, what am I going to call myself, right? So what should somebody maybe do? If I come up with an original name and somebody has it in Iowa, that's a problem? Or how should I go around finding a name that's original that doesn't step on somebody's toes?
Yeah, so that's a great question. When you're, as a company, I think, starting out, branding yourself and creating your market brand is critical. So first, you are able to use, if a company in Iowa is using a trademark, but you want to use the same name, you can probably do that. It depends, but in order to trademark something, you have to fit into one of 45 different classes of goods or services. So
wow, 45.
you can. So
That's
some
a
of these.
group.
Yeah.
That's why he gets paid the big bucks.
Yeah.
So some of these names are so powerful that they cover all of them. So Coke, you can't use Coke. But for most trademarks, they're applicable to a certain type of goods or services. So you might have, the Rio Grande brand, and that would be in class 41 for educational services. But somewhere in Iowa, they might be able to sell something called Rio sponges, because no one's going to confuse those sponges as being made by the same people who put on or provide the Rio Grande educational services.
Gotcha.
So it's all about consumer confusion and whether or not consumers would be confused by your use of the trademark with the existing use of the trademark in Iowa or wherever. So
people come up with all kinds of stuff, like I'm in video production, they come up with some, Happy Frog Productions. Or
Yeah.
some odd names.
Yeah. So who decides that? Do I just say this is my name and then I go to where to see where I
Google it and
fit?
see if somebody's out there?
Yeah. Where do I go to fit these categories to see if I'm going to be apply or not?
Well, so the first thing you would do is you would go to uspto.gov and you would click on the trademarks link and you would look in their trademark engine search site, which is TESS or for short. You would punch in the mark that you want to look at and it would produce a list of results, or maybe not, depending on how many people are using your trademark or not. So
Good point.
you would figure out then if there's a registered trademark. And if there isn't, you're in pretty good shape.
Okay.
If there is, then you need to look at the mark and figure out, okay, are they competing in a class of goods or services that we're going to be competing in? So it's the educational services versus clothing type comparison or something like that. If they're not, then you can probably proceed in trademarking, or at least applying for the trademark with the USPTO. And that is a process that typically costs about $275 to register a trademark with the Patent and Trademark Office.
And then I guess you could go backwards on that, say I've got this trademark. Should you every so often go and check if somebody else is using it?
Right. So one of the things about keeping your brand really valuable is making sure there aren't people out there using your trademark in your area that what we call dilute your brand name. So again, the idea is that consumers identify with your brand and identify your trademark with what you're producing. And if a whole bunch of different people are using your mark, then the identification isn't going to be that strong. So Coke is really strong, right? But there are lesser trademarks out there that aren't quite as, or aren't nearly as strong. So you want to make sure that you're out there policing and making sure that people aren't using your brand name. Now, unfortunately, to get them to stop, if they don't want to, the only way you're going to be able to do that is to file a lawsuit against them.
That's what I was wondering, what the next step is. So there is a conflict, is the first step that they would contact like somebody like in your office, and you call up the other people and it's like, hey, don't do that, and then they stop and everything's cool? Or do you immediately fine them? And
Well, yeah. So trademarks are they are owned privately, so it's a private property right, and it's going to be incumbent upon the trademark owner to protect their own trademark. As the Attorney General, we don't represent the private trademark holders. We represent Ohio State or Ohio U or other state
Right.
entities, but we don't represent P&G.
Okay.
So we can't help in that regard when it comes to federal trademark protection. It's incumbent upon yourself to protect your trademark.
okay. So after that, do those same rules apply to the other ideas that a company may hold? Production,
Maybe
line
it- yeah.
secrets, or
Yeah, maybe it's not the name, but maybe it's a software that they're developing or a particular piece of hardware or tool or something.
Right. So in terms of intellectual property protection,
Right.
yeah. So
yeah, the same rules apply across.
with the idea that
One's your branding and your
sure.
symbol, and now we're talking
Yeah, now-
deeper into the company,
Yep.
how we do things, and
Yep.
maybe I have a certain way of, roasting coffee
Right.
that's better than somebody else.
Yeah, so when you think about protecting your idea, and that's the kernel, really the substantive thought behind your company, you're either going to look at patent protection, which are probably most likely, or perhaps copyright protection. And we'll talk about copyright. I guess I'll talk about that second, because copyright's more limited to software companies. So for a manufacturing company or a medical device company or a company of that nature, you're looking at patent protection, and you're looking at an idea, and you have to decide early on whether or not you want to protect your idea by using patents or trade secret protection. So the question is then, and that's what I tell folks is, if you're going to use trade secrets, the question you have to ask yourself is, can someone reverse engineer what you're doing? Can someone figure out the secret on
So
their
a
own?
trade secret is not registered anywhere.
No.
You just tell everybody in your company.
Right. You have to
Don't
trade,
pass it on.
Yeah, so trade secrets are exactly they
That's
have
like
to
the KFC
original
Secret
recipe, right.
Yeah, the secret recipe.
That's not registered somewhere. That's
No.
just like between me and you.
Yeah.
It's to go back to Coke. Their formula is
Yeah.
guarded in some vault in Atlanta somewhere that
Right.
one person knows the combination to, or something like that.
But if somebody figures it out, can you go after that person?
yeah, so trade
Or
secret.
something close to it?
Yeah, so trade secret protection arises. You get trade secret protection if the secret has value, and if you've taken reasonable steps to keep it secret. You don't have to, hire armed guards to protect it, but you just act reasonably.
Yeah.
Now, once the trade secret is in the public domain, if it reached the public without any sort of foul play, then it's no longer a secret. I mean, secret. If it's not secret, then you
Okay.
can't have a trade secret.
All
So
right.
that's why if Apple wants to trademark something in their iPhone or trade secret something in their iPhone, they have to ask themselves, okay, someone's going to buy our iPhone. Can they take the iPhone apart and figure out what that trade secret is, or figure out what that technology is? And if they can, it's probably not a good candidate for trade secrets because someone can figure it out on their own.
Right.
Typically with trade secrets, what you're looking at is methods of production, ways to make things that are unique. So, you might make, your phone or your tablet, and you might have a result that's people know about, but there's certain steps that are the magic sauce which make this particular product great. And you can't figure it out by just buying the product. You can't reverse engineer something. And that typically is when you're looking at making chemical compositions or sometimes drugs. But with trade secrets, I think the real key is what we talked about, taking those reasonable steps to keep things secret. So if you've decided that you want to go down the trade secrets route, you have to take steps to keep that information secret. So you have to have, I would recommend that your employees sign confidentiality forms. So they're not going to, they're under a legal obligation not to disclose this to third parties.
Could that be called also a non-compete or not?
It could be wrapped into a non-compete, but they're two separate provisions. And if you're in a market or if you have employees that are highly skilled, maybe a non-compete is a good way to go. In Ohio, you can get up to 2 years for a non-compete if it's reasonable and within a reasonable geography.
Right.
So you need to take reasonable steps, confidentiality agreements. If an employee is going to leave, you need to make sure that you are able to access their own devices to make sure that you're able to take any trade secrets that may be on their devices and remove those, or make it incumbent upon them to do that act on their own and make sure that they turn back all the information that they have.
Yeah, that's tough because you could take pictures with your phone that gets uploaded to iCloud and on your local PC, and who knows where it goes out from there.
And one way to maybe address that is in your confidentiality agreement is to spell out how and where you can put your secret information. So
on a private server.
A private server, right.
Server, yeah. Before we go down that rabbit hole, I have another question about the secret thing. Is that something that obviously, do you pay somebody for? I mean, is that not a patent, but if you call it a trade secret, do I have to tell you, the Attorney General, that it's
you
a
don't
secret?
tell
You just say, nope, I'm not saying nothing.
The wonderful thing about trade secrets is that they are free. So you have to take the steps to maintain their secrecy.
Okay.
And I would recommend cataloging your trade secrets as they come up and marking them confidential and proprietary. And if you're going to pursue the trade secrets route, do it, understand that you're going to do that, and then take steps going forward rather than 6 or 7 months into the thing saying, well, we should protect these with trade secrets, and then trying to go back and backdate everything
backwards.
and work backwards. So make the decision up front and then mark everything as confidential and proprietary that is a trade secret. Document what you have as a trade secret so that when you're looking through someone's computers or that you see someone is using information on their phone, that you can make sure that they're not going back to their house or things like that. So,
and you could probably tell people, don't bring your phone in to work.
Right.
Right.
Or if they're going to use their phone, it needs to be encrypted. So you have to have a password or
I know certain places they don't allow you to have a camera on your phone. So
that's tough now, but
it is. But they make them take them out. Take them out to where they can't have them.
And you look, it's not. You can make sure, or you can put in if you're really working with very sensitive secrets, you can require people to do work in the lab, and you can set up computers that are permanent.
You set up the equipment there. Yeah, it's a good.
Now we'll go on to not copyright, but
patents.
But also on copyright, say like if I wrote something or did something, I've heard that you can like put it in an envelope, send it to yourself, and then that's something. Have you ever heard of that?
I don't know.
I've not heard of that.
Yeah.
Like lyrics to a song, I would put it in an envelope and I get it back, and it was stamped and dated. That's proof that I did that at that point in time.
Oh.
Yeah. So copyright protection
from the U.S. mail or something.
Right.
Okay.
It goes to the government at that point. I guess that was a.
Yeah, so what's interesting about copyright protection is that you don't need to register your copyright with the Copyright Office. Copyright protection attaches or begins automatically when you put something on paper or on your computer.
It's published in some way.
It's published in some way. And that could be on your own computer and saved to your hard drive. That counts. So your lyrics, when you write them on your computer and you save them, to your hard drive, or you put them on a DVD, copyright protection has attached to those lyrics.
Automatically.
Automatically. Now you can go ahead and register it with the Copyright Office, and it's a cost of, I think, $25. So it's not a big cost. And if you ever have to sue someone, it's an advantage to be registered. But you don't need to register it with the Copyright Office.
Okay. So now patents. I see advertisements on television that it's really expensive. You need to hire a bunch of people, and it's
Yeah.
ridiculous. What's the deal?
Yeah. So patents for smaller companies, patents I think pose the greatest question or most difficult strategic dilemma, because that's the IP that you're most likely to deal with. I mean, aside from trademarks, they're all going to have their trademarks. Patents typically are going to cost, to actually file a full-on patent application and get it issued, you're going to look at $10,000 to $15,000 to $20,000 to get that patent issued.
And that's the attorney's fees, or the
That's-
fees from the government?
No, that's hiring a patent attorney to do the work for you.
Okay.
Now there are different ways that you can go about it to limit costs, or to kind of do it in stages. The Patent Office allows the filing of what's called a provisional patent application, and that's kind of a placeholder patent. You put down your idea. It could be a publication that you've done, or something that indicates that you've come up with this idea that you're going to try to patent. And you submit it to the Patent Office, and then you have a year. That buys you a year to then file what's called a non-provisional patent application, or the real application, the official application.
Is that when you see on a product patent pending?
Once you file your patent, then you can put patent pending on it.
Okay.
Right? So the provisional application will only cost, in your range of, it could be $700 up to maybe $2,500, $3,000. So $2,500, $3,000. So in that range, you're looking at a much lower cost. It gives you a year to figure out the real value of your idea. Sometimes folks don't know how valuable their idea is. And the thing with patents is that patents don't give you the right to sell your product. Okay? Patents only give you the right to stop someone from selling a product that has that idea in it.
Right.
So it's the right to stop others from using your idea. Now you could still have a great product that uses your idea, but it could also infringe on someone else's patent. You're making a car that has a new engine type, but you're still using tires that infringe someone else's patent. So that's kind of would be my analogy. So you still have to, that doesn't mean you can sell your product, but it does mean you can exclude others from using your idea. So you need to figure out the value of that idea in the market. And that you have to figure out how easy is it to make the same product in a different way. What's the difference in value between your product and a product that's made in a different way or uses different technology? Is it only worth $3 or $4, or is it worth $100 to $200 or $300 in the marketplace? I mean, what are consumers going to prefer?
So what's the cost? Is it like whenever you file a patent, then you have lawyers that go out and research it to make sure that that's true?
So there's the fees. There's several $1,000s in fees to prosecute or to apply for a patent that you have to pay just to the Patent Office. But then attorneys have to draft the patents. To the extent that you can work and work with them to draft the patent, you can try to lower costs. But attorneys have to draft the patent, and then you have this. Oftentimes, you have a back and forth with the patent examiner. So you'll submit your application, and then the examiner will say, "I don't think this is patentable because of this was already known or this was already known." And then the attorney will say, "No, it is patentable because of this reason, this reason, this reason." And the examiner will hopefully say, "Okay, we'll allow your claims now, and then the patent can issue." So it's a process that will last for a couple years, 1 to 2 years, maybe even longer. Some last 4 or 5 years.
Okay. In our last minutes, is there any advice that you would like to give the audience, or hints, or those things maybe we forgot to get to?
The one thing that we didn't get to in terms of intellectual property advice is when you are hiring someone to develop software or develop something that would be protected by copyright, the default rule is that they own what they're developing. So if you're hiring a software developer to develop software for your company, unless you contract or put it in a contract, the default is they own it, and they own all the rights to it. So when you're hiring someone like that, whether it's a software developer or someone to do artwork for you or someone to take pictures for you, you need to make sure that when you contracted with them, that you've obtained the necessary rights to use that work in your company. And if it's important to your company, make sure that others can't use that work, that the independent contractor can't go out and sell what you've just paid them to do to your competitor. So you need to think about that when working with or hiring someone to do
Sort of
those
like
types of
me
works.
as a photographer, I kind of own the rights to my photographs.
Right.
You have the right to reproduce them possibly or buy those copies from me.
Right.
But it may not be one of those things where I have the right to take your photo and put it in a stock photo library and sell that photo for other companies or somebody to use. You know about these stock
Yes,
photo
that's
things?
right. That's right.
So that would probably be, that would have to be spelled out when I sold the picture to you, or an agreement later on that I can still sell your image
Right.
to someone else.
Exactly. Yeah, that's exactly right. You need to, when you're buying something like that, whether it's, like I said, whether it's software, photos, a a marketing plan,
Yeah.
you need to figure out how you want to use that and make sure that in the contract with the person that you've hired to do it, you have the sufficient rights to use it as you need to use it for your business.
I think I had, I don't know if you have it ready, a graphic that shows his contact information. If somebody wants to get in contact with you, what would they do? And
They can call me at 614-466-4066. I'm always happy to take questions on IP issues. And they can email me at isaac.molnar@ohioattorneygeneral.gov. It's a long email address, but I promise you if it's worth typing it in if you have a IP question.
I think there's ohioattorney.gov/
Yeah.
intellectuals/property, right?
Yeah, so we also have if you want to, I have a website available that's a great resource for smaller companies, and that's available at ohioattorneygeneral.gov / I think it's commercialization, but if you search Ohio Attorney General and economic development, you'll find my website.
Okay.
You'll also find a useful manual on economic development
There
that
we go.
handles a lot of other issues.
You found it.
Yeah, so there you
There
go.
it is.
So it's a good resource for especially smaller companies.
Okay.
Great.
Well, thanks for watching, everyone. I hope you've gained some valuable information, and stay tuned next month for Agri Talk.